What are the sources of administrative law? If you look at criminal law, it is primarily consolidated and written down within the criminal law statutes. Similarly, if you look at environmental law, there are specific statutes like the Pollution Prevention Acts, the Environment and Wildlife Protection Acts. But when you look at administrative law, there are no dedicated statutes, which means that administrative law is an uncodified law. Then, what are the sources of administrative law? Well, administrative law is based on or drawn from a wide range of sources, which can be classified into three categories: the Constitution, statutory sources, and non-statutory sources. For example, when the executive is performing any of its functions, they should not violate any of the fundamental rights guaranteed by the Constitution. They should be in accordance with the directive principles of state policy, and they should follow the concept of judicial review. They should also follow the provisions related to the administrative services and the principles of separation of powers and delegation of powers. So, this is how the Constitution is a source of administrative law. Statutory sources of administrative law means that the executive should act within the framework and within the limits set by the various acts of the central and the state legislatures. For example, the Income Tax Department, which is the executive, should function within the limits set by the Income Tax Act and any other laws made by the legislature. When the tax department is making any bylaws, rules, regulations or orders, they should be within the framework and within the limits of the delegated legislative functions, specifically delegated by the legislature. And then there are statutes which specify how the administrative officers like the IS, IPS, IFS, etc. should function. So the executive should adhere to all such statutes also. Non-statutory sources include different judicial decisions which can become case laws and various common law principles, principles of natural justice, administrative practices and customs, reports of various committees and commissions, any international laws, treaties and conventions to which India is a signatory, academic writings and commentaries, and also government policies and manuals. To summarize, administrative law originates from various sources that collectively establish the legal framework for governmental agencies and their interactions with individuals and organizations. These sources of administrative law define the creation, the powers, the procedures, and the limitations of administrative bodies. They also ensure that the administrative agencies respect individual rights and fulfill their duties effectively and lawfully. And each of these sources contribute to the checks and balances that prevent the misuse of power by the executive and protect public interest.